Your Honour, may it please the Court, my name is Bale, initial B. I appear on behalf of the defendant, Sonny Barger, charged under the Criminal Code 1899 Queensland for one count of assaulting a police officer pursuant to section 340 subsection 1b and one count of possession of a thing used to play an unlawful game under section 233. It is alleged that at the time, my client had in his possession a backpack containing equipment used for the purposes of playing two-up, an unlawful game. My client has pled not guilty, Your Honour, and pursuant to section 590 A, subsection 2e, we seek to tender submissions prior to trial. We request that the defendant's backpack and its contents be excluded at trial because it lacks the requisite threshold for the relevance to both section 340 subsection 1 and 233 of the Criminal Code, and was knowingly obtained by Constable Tansom unlawfully with a blatant disregard for the law. Alternatively, we plead that the backpack and its contents are excluded under Your Honour's public policy discretion. Your Honour, I'd like to begin by contesting a fact and issue with the Crown's case, being an absence of relevance in connection with the material elements of section 233. The elements to be established by the Crown necessary to land a conviction are that my client was in possession of game equipment that was or has been used or is intended to be used to play an unlawful game. There is no rational causal link between the backpack and a probability of previous use or future intention to use the equipment to play two-up. Additionally, Your Honour, by definition outlined in section 1 of the Code, possession is having under control any place whatever and for the use or benefit of the person whom the term is used. There is no evidence of my client having the equipment under his control at the time of the offence. He was in the car of his de facto wife, Mary, when he was stopped by Constable Tansom, who continued to search the vehicle where the backpack and its contents were found. The car was not the property of my client, and every item inside it was not under his possession. He was nothing more than a mere passenger in the vehicle. If possession is satisfied in the case, the ordinary meaning would need to include being near or in the vicinity of something, which is not expressed anywhere in the common law or legislation. At no point did Constable Tansom witness my client with the backpack in his control. He therefore did not witness my client in possession of the backpack. There is no evidence indicating that the backpack was my client's. Further, we would like to clarify that my client's exclamation, "You would be low enough to steal a man's two-up gear," after he was notified of the confiscation is a broad statement spoken without tact due to the frustration and inconvenience of the situation, and does not indicate ownership of the equipment. For the charge under section 340 subsection 1b, I would like to state the established precedent in Goldsmith and Sanderland. Evidence is relevant if it could rationally affect, directly or indirectly, the assessment of probability of the existence of a fact in issue in the proceedings. It is our submission that there is no correlation between the evidence and in 340 subsection 1b and the backpack and its contents. It has no influence in assessing the probability that my client assaulted, resisted, or willfully obstructed Constable Tansom while acting in the execution of his duties as a police officer. It is for these reasons outlined that the backpack and its contents should be inadmissible as they lack the necessary thread relevant to the elements of the offences my client has been charged pursuant to. If Your Honour is not satisfied that our defence of inadmissibility outlining evidence contrary to possession, we further submit that Your Honour enliven the common law public policy discretion to exclude the backpack and its contents for blatant disregard taken by Constable Tansom for the law when the evidence was confiscated, outlining in Bunning and Cross. We would like to acknowledge the power granted to police officers to search a vehicle without a warrant under section 31 and 32 of the Police Powers and Responsibilities Act. It is our submission, however, that Constable Tansom's shirt did not fall within the categories outlined under these provisions. In Constable Tansom's search, when he searched the car, there was a deliberate breach of section 32 subsection 2a of the Police Powers and Responsibility Act 2000. This provision states that a car can be searched without a warrant if they are or have committed an offence against the Summary Offences Act 2005 10C. Section 10C, subsection 2, outlines that a person who is in a vehicle in a public place must not wear or carry a prohibited item so that a prohibited item can be seen from the public place. Section 173, capital E, capital A prohibited item is an item of clothing that displays a name of an identified organisation as per paragraph A, or any symbol such as the symbol 1% as per paragraph B, subsection I. The alleged prohibited item was my client's shirt, which had Buzz Cogs and 1%, but it was a symbol that read. Although similar to the word Buzz Arts, which is an identified organisation under section 173, capital E, capital A, the Buzz Cogs are not an identified organisation. Furthermore, I'd like to contest the words 1% were displayed written on my client's shirt, not with numerical 1 and the symbol 4%, as prohibited per the Liquor Act 1992. At the time of the offence, there were no grounds for the police officer to search the vehicle without a warrant for circumstances unrelated to Section 10C of the Summary Offences Act. Constable Tansom ignored my client's pure explanation of what was written on his shirt, and therefore all acts and omissions following were in breach of Section 32, subsection 2A of the Police Powers and Responsibility Act. It was this blatant disregard for the law by Constable Tansom that led to the evidence being confiscated. There were no pressing circumstances to prevent the constable from acting within the law. The gravity of contravention was low. No major crime was committed or prevented due to the immediate seizure of the backpack and its contents. Your Honour, for allowing this evidence, you would encourage officers of the law to skip the checks and balances of the law and have a procedural shortcut to creating their own law, which they are meant to be following or practicing. I would like to conclude my submissions, Your Honour, unless Your Honour requires any submissions. The defence rests. Thank you, Your Honour.